What if I told you that starting January 1st, 2026, you might never have to register another suppressor or short-barreled rifle again? Not in some distant future. I'm talking about real lawsuits happening right now that could completely eliminate the NFA registry. But here's the kicker. Congress already killed the $200 tax stamp, and that one move might have accidentally destroyed the entire legal foundation holding up the registration system. Look, I know what you're thinking. Another clickbait video promising the NFA is going away. But this isn't wishful thinking or political theater. This is about a massive legal contradiction that Congress created when they zeroed out the NFA tax in what they called one big, beautiful bill this summer. Here's what we're going to cover. First, exactly what changed in that legislation and why it matters. Second, the specific legal arguments being used in multiple federal lawsuits right now. Third, what happens if these cases actually win, and why your opponents are panicking so hard they want to jack the tax to $5,000. And finally, the realistic timeline and what you need to know. Before we dive in, I am not an attorney. This is not legal advice. This video is for information and entertainment purposes only. Always consult a legal professional in your jurisdiction for any specific legal questions. If this information is valuable to you, hit that like button and subscribe for more content like this. So here's what actually happened that nobody's talking about. The so-called One Big Beautiful Bill that passed this summer contained a provision buried deep inside that eliminates the $200 excise tax on suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons as defined by the National Firearms Act, effective January 1st, 2026. Let me read you the exact language. This bill contained a provision that would, among other things, eliminate the burdensome $200 excise tax imposed by federal law on suppressors, short-barreled firearms, and any other weapons as defined by the National Firearms Act. Translation: the tax grab is gone. You won't pay the $200 after the effective date. But, and this is where it gets interesting, the feds left the registration process completely in place. Now, why is this a problem? Because for nearly a century, the legal justification for the NFA registry was that it tracked who paid the tax. It was essentially a receipt system. No tax means the original justification just evaporated. Silencer Shop summarized it perfectly. $200 tax stamps for suppressors, SBRS, SBSS, and AOWS reduced to $0 starting January 1st, 2026. NFA process and registry remain for now. That phrase "for now" is doing a lot of heavy lifting because multiple legal challenges are attacking exactly this contradiction. Here's where it gets really interesting. This isn't just one lawsuit from one organization hoping for the best. We're talking about a coordinated legal assault from the biggest names in gun rights. On August 1st, 2025, a coalition of 4 major organizations, the American Suppressor Association, National Rifle Association, Second Amendment Foundation, and Firearm Policy Coalition, filed a joint federal lawsuit in the District of Missouri challenging the constitutionality of the National Firearms Act. But they're not just attacking on one front. They're using a two-pronged strategy that's brilliant in its simplicity. First, they're arguing that Congress exceeded its constitutional authority. Here's their logic. Congress originally justified the NFA under their taxing power. But if there's no tax, then there's no taxing power being exercised. You can't hide gun control inside tax law that doesn't actually tax anything. Second, and this is where the Supreme Court's recent decisions come into play, they're arguing the registration requirement violates the Second Amendment under the new historical tradition test. Let me read you the exact language from the Second Amendment Foundation. The lawsuit also asserts that the NFA's registration regime for suppressors in short-barreled rifles violates the Second Amendment. The complaint urges that there is no tradition that supports the NFA's registration regime for protected arms, such as suppressors in short-barreled rifles. This is huge because under the Supreme Court's current framework, the government has to show there's a historical tradition of similar restrictions. And guess what? When the Second Amendment was written, there were no federal firearm registries, none. The Firearm Policy Coalition puts it this way. This important case challenges the NFA on 2 separate grounds. It exceeds the limited enumerated powers granted to Congress in Article 1 and violates the right to keep and bear arms protected under the Second Amendment. They're basically saying Congress can't do this constitutionally, and even if they could, they're violating your Second Amendment rights. Now, here's how you know this legal strategy has teeth. Look at how the opposition is responding. Senator Chris Murphy, a Democrat from Connecticut, tried to slip an amendment into a defense spending bill that would skyrocket the National Firearms Act tax to $4,795. Think about that for a second. If your opponent's immediate response is to jack the tax from $0 to nearly $5,000, it's because $0 absolutely terrifies them. They know that without the tax, their entire legal justification crumbles. This isn't some minor policy tweak. This is panic legislation designed to shore up a legal foundation that's about to collapse. So what happens if these lawsuits actually win? Let me paint you the picture. First, no tax. That part's already locked in with the January 1st, 2026 start date, regardless of the lawsuits. Second, no registration. If the courts rule that the ATF can't enforce NFA registration on these now untaxed items, the entire registry system for suppressors and short-barreled rifles becomes legally unenforceable. Third, and this is the big one, suppressors and short-barreled rifles become normal purchasing items. You walk into a store, pass your background check, and walk out with your suppressor. No forms, no waiting, no asking permission from the federal government. Now, I'm not going to sell you a fairy tale here. The DOJ and ATF are going to fight this with everything they have. Expect them to argue that the registry can stand on other constitutional grounds, like the Commerce Clause. They'll probably try to get courts to dismiss on technicalities. And yes, some media will frame this as extremists dismantling safety laws. We've seen that script before. But here's why this time is different. The legal terrain actually favors the challengers. The tax is gone. That's not in dispute. The Supreme Court's historical tradition test is the law of the land, and the lawsuits are laser-focused on that exact contradiction. You simply can't use a dead tax to justify a living registry. The legal logic doesn't work anymore. Let's talk timeline, because this isn't happening overnight. Federal litigation moves slowly, especially when it involves constitutional challenges to major federal laws. We're probably looking at 18 to 24 months minimum before we see any final resolution, and that's assuming everything goes smoothly. There will likely be appeals regardless of who wins at the district court level. But here's what's encouraging. The legal arguments are strong, the timing is perfect with the tax elimination already in law, and the Supreme Court's recent Second Amendment jurisprudence creates favorable precedent. The key thing to understand is that even if these specific cases don't win, they're establishing the legal framework for future challenges. Every court filing, every legal brief, every judicial opinion builds the foundation for the next case. And remember, the government has to defend a position that's getting weaker by the day. How do you justify a registry system based on tax collection when there's no tax to collect? Look, I can't predict the future, and courts don't always rule the way logic suggests they should. But for the first time in decades, we have a real legal path to eliminate not just the tax, but the entire NFA registration system for suppressors and short-barreled rifles. The foundation is cracking, the legal challenges are filed, and the opposition is panicking. Whether this succeeds depends on continued legal pressure and public awareness. If you found this breakdown valuable, smash that like button and subscribe for more analysis like this. And when you're done here, check out one of the other videos on the channel for more Second Amendment content. The fight for your rights never stops, and neither should your education about them.